takeaway section, gentlemen. So I give each of you 3 to 5 minutes. Tell me what you want those attending today to leave here with.
Well, if I can start, I would say now is a good time to do an assessment of whether your organization could benefit from an arbitration agreement with a class or collective action waiver. I think it's too soon to put one into effect. I would hold off and find out just what the Supreme Court decides in this epic case, but start thinking about whether it might make sense for you. Go through some of those pros and cons that I've set out in the presentation. Think about the culture of your organization. Think about the areas at your organization that might be ripe for class claims and whether the arbitration agreement with a class and collective action waiver in it might give you some opportunities to minimize that risk. Having said that, though, you may go through that assessment and decide that it's not for you. Maybe it's not a fit for the culture of your organization. Maybe it's just not going to cut that risk down enough to make it worth the effort of rolling out the agreements and collecting them and making sure that you've got them in a way that they can be enforced if you want them. But I think this is the time to go through that exercise because I think the door will be opening up to employers to go down that route where it makes sense for them early in 2018. Related to that, and I think you could make this sort of your overall assessment, it's tied to the idea of issue certification. Think about when there are situations where you do want to be in court, where you do want to go through a class procedure, and where class-wide resolution can work to your benefit. That doesn't mean opening yourself up to whatever the plaintiffs might want to assert against you on a class basis, but there can be opportunities for defendants to avail themselves of the class mechanisms in a way that will advance their cause and help them speed the resolution of complaints that have been asserted against them.
Chad McKay.
Sure, and I think just a few points from what the portions I talked about today. I mean, one thing certainly keep an eye on the Fairness in Class Action Litigation Act. I mean, it could fizzle away and turn into nothing. It could be a game changer depending on what happens. I think Congress has some bigger fish to fry at the moment that have kind of set that on the back burner, but it's not going away. It's something that matters to the bill's sponsors, and it's something that a lot of folks are keeping a close eye on. And if you're in the class action arena, you need to do the same thing. I think talk about from the settlement section. I think settlements are a great idea in the class action context, the same as they are in any other litigation. Again, think of it as from a defense standpoint. Think of it too. This can be beneficial to the defendant too. Nobody wants to settle and pay out a bunch of money, but if you can get a fair settlement put together with a class, if there's an injunctive component, if it's fixing a form, whatever the case may be, where there's some real relief, and you're not having to have a huge financial outlay, then that's something to think about. And certainly, again, just all the benefits of settlement to begin with. But again, know the factors and look at your jurisdiction, look at what the courts are looking at there, and look at for those red flags. The data breach realm, I think that's an area we're going to continue to see it. I think we're going to see more legislative efforts as well. You've seen a lot more privacy-related laws getting passed in a lot of states, for example, that can then be used to create potential causes of action where they might not have it in a common law scenario. So I think that's an area of the law to watch, and I think to the extent, advising our clients and, looking out again for our own law firms and law offices and that as well. I mean, it's an important issue, and I think really that's where being ahead of the game and having the security measures, having your plans in place, and knowing what you're going to do if and when one happens, that's gonna help dramatically. And then if it does, implement that game plan. Use the right. Everyone's going to be a little different, but you want to address it. You certainly don't want to have, and that's the one you see in a lot of these articles, where a breach happens and no one hears about it for 3 months. that's usually not a good thing because that's the time where something bad could have happened. So that's one. Keep an eye on that area law, and again, I think being up ahead of the game on that, being proactive is the right thing. And then the last topic I had in there, going back to the early resolution. Again, not a bad idea. Good things to do, as in all things, but I think that's a good place to just have that reminder of, the importance of having professionalism, because I think if you can get that good working relationship with opposing counsel, whether you're on the plaintiff side or defense side, you can trust each other, you're shooting straight, then you can get these things done a lot more, these class actions and any litigation done a lot more efficiently and effectively. Not to say you're not going to end up trying a case, not to say you're not going to have motion practice, but I think you can get rid of a lot of the things that really drive up the cost with needless disputes and that. So that's all I've got for today.